The American justice system just admitted it's been protecting bad policing for 40 years. A unanimous Supreme Court decision destroyed the legal doctrine that let courts ignore officer misconduct before shootings. For gun owners, this isn't just legal news, it's survival information. Subscribe now because this could save your life. The statistical evidence of systematic judicial failure. Between 2005 and 2020, federal courts dismissed over 87% of police shooting cases without examining whether officers created the dangers they claimed to fear. This wasn't random. It was systematic judicial protection of law enforcement through a doctrine called moment of threat. University of Chicago Law Review research documented this pattern across every federal circuit, showing courts consistently refuse to analyze officer decisions, tactics, or training violations that led to shootings. The Administrative Office of U.S. Courts reported that plaintiffs won only 3.2% of excessive force cases that reached trial between 2010 and 2019. This staggering failure rate didn't reflect lack of merit. It reflected judicial unwillingness to examine the full truth. Courts focused exclusively on the final moment when officers pulled triggers, treating everything before as legally irrelevant. Officer mistakes, tactical failures, training violations, even deliberately creating dangerous situations. None of it mattered if the officer testified to feeling threatened in that final instant. This systematic failure violated basic constitutional principles. The Fourth Amendment requires force to be objectively reasonable, but courts evaluated only subjective fear in isolated moments. The reasonableness requirement became meaningless when courts refused to examine the reasonable alternatives officers had, the reasonable tactics they should have used, or the unreasonable decisions they made that created the crisis justifying force. How courts protected officer misconduct through legal gymnastics. The moment of threat doctrine operated through deliberate judicial blinders. Even when officer misconduct was obvious, courts declared it legally irrelevant to Fourth Amendment analysis. Officers could violate department policies, ignore explicit training, make tactically absurd decisions, and courts would still grant qualified immunity and summary judgment as long as the final moment involved claimed fear. The Barnes case exemplifies this perfectly. Officer Robert Felix Jr. stopped Ashton Barnes for $67 in unpaid tolls. When Barnes attempted to drive away, Felix jumped onto the car's door ledge, a tactic explicitly prohibited by police training manuals nationwide. The Police Executive Research Forum's guidelines state officers should never position themselves in vehicle paths or grab moving cars because it creates the very danger justifying lethal force. Yet, both the District Court and Third Circuit refused to examine this tactical decision. Their reasoning revealed the doctrine's absurdity. Courts acknowledged Felix violated training, but declared this irrelevant because the relevant inquiry focuses on the moment force was used. This circular logic meant officer misconduct, creating danger, became invisible to constitutional analysis. Courts evaluated only whether Felix faced danger when he fired, not whether he created that danger through prohibited tactics. The Fourth Amendment's reasonableness requirement was gutted. This pattern repeated across federal circuits. Courts developed standard language dismissing entire categories of officer conduct as legally irrelevant to the Fourth Amendment analysis. Pre-shooting decisions, tactical choices, training violations, policy breaches, all of it disappeared from constitutional evaluation. The moment of threat became a black hole consuming everything. Officers did before pulling triggers, leaving only their claimed fear in isolated moments as the measure of constitutional reasonableness. The training gap that courts ignored for decades. Police MIs across America teach specific de-escalation protocols, tactical positioning, and threat assessment procedures designed to prevent unnecessary shootings. The International Association of Chiefs of Police publishes comprehensive guidelines on creating distance, using cover, issuing clear commands, allowing compliance time, and calling backup before resorting to force. These aren't suggestions. They're standard training taught at every academy. Yet, under moment of threat doctrine, courts systematically refuse to examine whether officers actually followed their training. A Justice Department review of 500 police shootings found that in 61% of cases, officers had clear tactical alternatives available, but chose not to use them. Courts dismissed this as irrelevant. The gap between what officers were trained to do and what they actually did became legally invisible. This created perverse incentives. Officers could ignore training without legal consequence. Departments could maintain policies they knew officers violated without accountability. The Fourth Amendment's protection against unreasonable force meant nothing when courts refused to ask whether officers used reasonable alternatives their own training required. Constitutional rights became theoretical rather than practical protections. The training gap revealed systematic failure beyond individual cases. When courts never examined whether officers followed training, they eliminated incentives for departments to provide quality training or enforce adherence to protocols. Why invest in comprehensive de-escalation training if courts wouldn't examine whether officers used it? The judicial system's refusal to evaluate training compliance undermined the entire framework supposedly designed to prevent unnecessary shootings. The disconnect between what police departments taught and what courts evaluated created a system where training became liability protection rather than conduct regulation. Here's what courts never asked. If police training teaches de-escalation to prevent shootings, but courts never examine whether officers actually de-escalated, is the training protecting citizens or protecting officers from accountability? The disparate impact on legal gun owners courts refuse to address. Statistical analysis from the American Journal of Public Health documented that legally armed citizens are 4.5 times more likely to experience force escalation during police encounters compared to unarmed citizens, even when behaving identically. A 2021 study tracking over 50,000 traffic stops across 12 states found that when drivers disclosed legal carry status, officers were 3 times more likely to draw weapons and twice as likely to order drivers from vehicles, even during routine stops for minor violations. Courts knew this disparity existed, but declared it constitutionally irrelevant under moment of threat standards. The National Fraternal Order of Police's survey found 68% of officers admitted heightened anxiety during stops, where drivers disclosed firearms regardless of behavior. Yet, courts allowed this anxiety alone to justify force escalation. Legal gun ownership became de facto reasonable suspicion, justifying increased force, and courts protected this through refusal to examine full circumstances. The Armed Citizens Legal Defense Network tracked 847 police encounters involving legal carriers between 2018 and 2023. In 23 cases, officers used force despite carriers' full compliance. Under moment of threat standards, 19 cases were dismissed because officers claimed fear the person might reach for their weapon, even though none did. Courts accepted hypothetical fears about constitutional conduct as justification for unconstitutional force. This wasn't constitutional protection, it was constitutional abandonment. Gun owners exercising Second Amendment rights faced Fourth Amendment violations courts refused to recognize. The moment of threat doctrine transformed legal gun ownership from protected right to legal vulnerability. The judicial double standard meant citizens could be punished for exercising constitutional rights, while officers faced no consequences for violating those same rights. The Supreme Court's unanimous rejection of judicial failure. Justice Elena Kagan's opinion didn't just change legal standards, it exposed judicial failure. The court unanimously rejected the proposition that Fourth Amendment reasonableness can be evaluated in isolation from the circumstances creating that final moment. Kagan wrote that totality of circumstances is not a suggestion, it is a requirement. Courts must examine the complete chain of events, officer decisions, available alternatives, and whether officers created the danger they later cited to justify force. The opinion's unanimity is crucial. All 9 justices, conservative and liberal, appointed by Democrats and Republicans, agreed that federal courts had been applying Fourth Amendment protections incorrectly for decades. This wasn't close legal question or partisan divide. It was fundamental constitutional principle that lower courts had systematically violated through moment of threat doctrine. Kagan's opinion makes clear that examining officer conduct before the shooting isn't optional judicial discretion. It's constitutional requirement. Courts must ask whether officers had alternatives, whether they followed training, whether they created danger through their own choices, whether the person's conduct was objectively threatening or constitutionally protected. Every decision point becomes legally relevant because the Fourth Amendment requires evaluating the reasonableness of the entire encounter, not just the final moment. The opinion's language eliminates wiggle room for lower courts to continue moment of threat analysis under different names. By requiring totality of circumstances, evaluation, and explicitly rejecting temporal limitations on that evaluation, the court closed loopholes courts might use to maintain protective judicial standards. This was deliberate, comprehensive rejection of the entire moment of threat framework and its underlying assumptions about constitutional evaluation. The Supreme Court essentially told federal judges that protecting officer convenience at the expense of constitutional rights is judicial malpractice, not legitimate legal interpretation. The tactical examination courts must now perform. The Supreme Court's ruling requires courts to examine specific tactical decisions that moment of threat doctrine declared irrelevant. Did officers create distance or close it? Did they use available cover or expose themselves? Did they issue clear commands or contradictory ones? Did they allow time for compliance or escalate immediately? These aren't abstract questions. They're the tactical fundamentals taught in every police academy. A 2019 Stanford Law Review study found that in 94% of cases using moment of threat standards, courts explicitly refused to consider officer tactics or alternatives, stating these were irrelevant to constitutional analysis. The Supreme Court obliterated that refusal. Now courts must examine whether officer tactical choices were reasonable given their training, the situation, and available alternatives. For gun owners, this creates accountability that didn't exist before. If you're lawfully carrying and an officer makes tactically unsound choices that escalate the encounter, courts can no longer ignore those choices. Officer decisions to close distance when they could maintain it, to step from cover when they could use it, to create confusion when they could provide clarity. All of this now factors into whether force was constitutionally reasonable. The shift from moment-based to totality-based analysis fundamentally changes how force encounters are legally evaluated and documented. This raises fundamental accountability questions. If courts never examined whether officers used their training, were officers being held to any standard at all, or were courts simply rubber-stamping whatever officers did? How totality of circumstances restores Fourth Amendment meaning? The Fourth Amendment protects against unreasonable seizure. The Supreme Court established in Tennessee v. Garner that shooting someone is the ultimate seizure under constitutional law. Yet, moment of threat doctrine evaluated reasonableness of that ultimate seizure based solely on officer subjective fear in isolated moments, ignoring everything that created those moments. The Barnes decision restores Fourth Amendment, meaning by requiring reasonableness, evaluation of the entire encounter. This means examining whether officer decisions were reasonable given their training, whether alternatives existed, whether officer choices created the threatening situation, and whether the person's conduct was objectively threatening or constitutionally protected. Constitutional scholar Erwin Chemerinsky noted, "This decision finally recognizes that multiple constitutional rights operate simultaneously. You don't lose Fourth Amendment protection simply because you're exercising Second Amendment rights. This is crucial for gun owners. Legal carry can't be twisted into blanket justification for force." Courts must examine whether officer fear of legally carried weapons was objectively reasonable given the person's actual behavior, compliance, and constitutional right to carry. The Fourth Amendment means what it always should have meant: protection against government force that isn't objectively reasonable when examining all circumstances, not just the final moment officers chose to use force. This restoration of constitutional meaning represents the Supreme Court's clearest statement. Yet that rights must have practical enforcement, not just theoretical existence. The evidentiary record that now protects legal carriers. Over 40 million Americans have concealed carry permits. FBI data shows law enforcement conducts approximately 50,000 traffic stops daily. The mathematical probability of police encounters while legally armed approaches certainty for regular carriers. Under moment of threat doctrine, these encounters carried heightened risk because legal gun ownership could justify force based solely on officer anxiety. Totality of circumstances standards change this fundamentally. Your behavior throughout the encounter, clear verbal communication, slow, deliberate movements, visible hands, precise command compliance, creates evidentiary record protecting you under the Fourth Amendment. This isn't just smart tactics, it's constitutional evidence that force against you was unreasonable. Equally important, officer behavior creates evidentiary record too. If they escalate unnecessarily, ignore training, create danger through poor tactics, or treat lawful gun ownership as threatening despite your compliance, that evidence can't hide behind moment of threat protection anymore. The complete evidentiary record matters now. This creates new accountability framework. Courts must examine what you did, what officers did, what alternatives existed, and whether the totality of circumstances made force objectively reasonable. Your constitutional conduct becomes evidence protecting you rather than justification for violating you. The evidentiary shift transforms how these cases proceed. Previously, officer testimony about fear in the final moment could overcome video evidence, witness statements, and expert analysis about what happened before. Now, courts must weigh all evidence equally, evaluating whether the complete record supports officer claims that force was reasonable given everything that happened, not just what happened in the final seconds. This makes comprehensive documentation, body cameras, dash cameras, witness statements far more powerful in protecting constitutional rights. Every interaction you have while legally armed now builds a legal record that either protects your rights or exposes violations that courts can no longer dismiss. The accountability revolution for armed citizens. This Supreme Court decision represents judicial recognition of systematic failure and correction of that failure through restored constitutional standards. For 40 years, courts protected officer misconduct through refusal to examine the full truth. 9 justices unanimously said, "Enough is enough." The Fourth Amendment means what it says. Totality of circumstances is constitutional requirement, not judicial discretion. For gun owners, this creates accountability that didn't exist before. Officers can't manufacture threatening situations through poor tactics, then claim self-defense. Courts can't ignore training violations that created danger. Legal gun ownership can't be twisted into reasonable suspicion justifying force. Your Second Amendment rights can't be used to destroy your Fourth Amendment protections. The moment of threat doctrine is dead. Totality of circumstances is law, and the constitutional protections you always should have had are now enforceable because courts must examine the complete truth rather than isolated moments of claimed fear. This isn't just legal change, it's restoration of constitutional meaning and accountability. This unanimous decision signals that constitutional rights mean nothing without judicial willingness to enforce them honestly and completely against government power. But accountability only protects those who understand it exists. Do you know your constitutional rights well enough to create the evidentiary record that protects you? Or will you discover these protections after you needed them? The legal system just admitted 40 years of failure and gave you constitutional protections courts had been denying. Subscribe and share this with every gun owner you know. This knowledge gap could cost everything. Comment on which judicial failure shocked you most about this story.